Can I change my child's name? What's the process for doing that? Does the other parent have a say or an opportunity to be heard on that matter? What's the decision-making authority or the process for the court? Those are the questions we're going to talk about today. I'm Michael Miller. I'm a partner at Cole Miller, PLLC. We're a family law firm located in Vienna, Virginia, serving primarily in the Northern Virginia area. I analyze challenges and I find affordable solutions for families and their family law needs. So in our preceding episode, we talked about the statute that provides for name change. It's at Virginia Code 8.01-217. Now, there is not a corresponding provision for divorce to change a name incident to divorce for children the way there is for spouse. So if you want to do a name change for child, it's going to be under this 8.01-217. So it's the same statute, the same process. You file the application, you file the filing fee, and then we'll talk about what the court's review is, and then the name change order would be entered. So the one thing that's kind of different here is in the case of a minor who has no living parents, then it would be the application for name change can be filed by what's called the next friend of the child. In the case of a minor child with both parents living, then the parent who does not join in the application for name change could be entitled to have a hearing as to, or at least notice of a hearing that the application has been filed. If they object to the name change, then the court would have an opportunity to have a hearing to determine the validity of that objection and whether the petition to change the child's name should be denied. However, if a party answers the petition to change name, then service on that party is not required. Now, if you apply to change a child's name and you can show by clear and convincing evidence that notice to the other parent would pose a serious threat to the health or safety of the child, then the court can waive notice. So it's kind of a process to go down in that if a parent files, you should give notice to the other parent. You don't have to give notice if they file an answer. If there's a threat to safety of the child, then then the court can decide if clear and convincing evidence is presented not to have the hearing and to go ahead and act on the petition. Again, clear and convincing, 3 standards of proof at law. The highest burden is beyond a reasonable doubt. That's the criminal standard. The lowest of the 3 burdens is preponderance of the evidence. That's the normal civil standard. And there will be several areas. We'll see the name change for a child here is clear and convincing. It's somewhere in the middle. We also see clear and convincing for cases of adultery and things like that. So the other thing here is in the case involving a minor, the court, after hearing, can also deny the application if it finds it is not in the best interest of the child to change the child's name. So, as I said, with regard to the adult name change, the kind of presumption or the normal course of business is you file the application, the judge reviews it, and enters the order just on the paperwork. It's kind of the reverse here with regard to the children, because the court has that higher duty to protect the welfare of the children. The court's going to look closely at changing the child's name, the reason it's being done, and so forth, because it kind of ties into our earlier discussion on custody and visitation that this is a legal custody matter where both parents shouldn't be making this decision. It shouldn't just be one parent changing a child's name because they got remarried and they want the child to have the same name as the step parent, or for other reasons like that. So a number of things that come into play here, both parental rights as well as the best interest of the child. But the process is there and the court's there to adjudicate that and make those decisions.